And I will pass this over so that I can see all of you while I'm talking. All right. So, yeah, like I said, I had meant to warn all of you before I went live tonight. That was my intention. Unfortunately, I got wrapped. I started playing with computer stuff, toys, and it ended up kind of locking down all of my access to my phone while I was talking to you, while I was working on it. And so I was ready to go, but I didn't have a way to get on a phone and tell you guys that I was going to go live because I was using it to attach. So I apologize that I didn't get to warn anybody. So I'm going to hold off for a few minutes. What we're going to do this evening, because I still need to write a script for tomorrow for NRSCV FEC. And the reason I'm holding off is because the case that I need to teach you guys about for tomorrow is so complicated. And I need to run through it. I basically need to teach it to somebody so that I understand it well enough to be able to write something short on it. So what we're going to do is we're going to go through it the long way. So this is going to be, we're going to do a full run through of this case called Buckley v. Valeo. And this case is kind of the standard framework that started where we are today in figuring out what the government is and is not allowed to restrict as far as campaign finance. The kind of tug of war is between the First Amendment and the right to free speech, and sort of the importance of keeping freedom of information as free, as open as possible, and all of the things on the other side that can happen when money comes into the picture. And so in 1976, I think is the year, maybe 1972, something like that, which was just right soon after Congress had written this sweeping law about the what's allowed to be done in campaign finance, how money is allowed to be spent. The Supreme Court came in and said what is and is not allowed to be done, and it was a huge case. This Buckley case is sort of the beginning of a line of changes that are echoing into today. And that line of cases, beginning with Buckley, goes straight through Citizens United and all those other famous cases, but particularly it goes through two cases, both of which have the same name. They are both NRSC, National Republican Senate Committee or something, v. Colorado. And they're called, generally, if you're talking about this subject matter, they're called Colorado 1 and Colorado 2. The Supreme Court case tomorrow morning is over whether or not to overturn Colorado 2. And so this whole chain of events, starting with Valeo, or with Buckley v. Valeo, and coming to essentially tomorrow, begins in 1976 with this Buckley case. So we're going to go through Buckley. We're going to do a full dive on it. I'm giving it a couple of minutes. Good evening. Good evening. How are you, Vader? Vader's attorney. And I'm just, waiting a minute because I did promise that I was going to warn everybody before I went live again. For those of you who missed my explanation, I was playing with I found a way to get two different iPhones to both be connected at the same time, which I'm really excited about. which I've never been able to get to work before and may never get to work again. But for right now, it's working. And the problem was that once I did that, it meant that there was no way that I could get to the app to warn you guys that I was going to go live. So everything was wrapped up and I was like, I'm ready to go and I can't tell anybody. So I just got to go and tell them like this. So here we are. But you're going to see why in a second, because check this out. What I managed to do, I'm pretty excited about. Let's see here. Because those of you who haven't been around a long time may not know that I really got my start on the whiteboard. My whiteboard is how I think, it's how I break things down, it's how my mind works. I have a lot of trouble sort of holding multiple pieces of information in my brain at the same time, kind of pinning 5 different things to the wall at once and looking at all of them together. It's like that space just doesn't really exist in my brain. So the whiteboard is how I do that. I put it all up on the whiteboard, I do it in different colors, and I move them around the whiteboard, and that's just how I think. And so I know production value, right? And so it's just how I work. And so tonight you guys are going to be in my brain for a little while as we work this out. But I'm pretty excited about it. I've got to do it the other way because when I point one way, it's pointing the other. Yeah, whiteboard. This particular whiteboard that we have right here, which is a 4-foot by 8-foot whiteboard that I found on. There was like some crazy sale. It was for sale, for like. It was less than $200 in 2009, and I've been using it. I have carried this thing various places. It's been carried it around, and it's amazing. It's my baby, but it is starting. The plastic on it is so bad at this point. It's really hard to clean, but it is how it's the inside of my brain. So all right, I'm gonna get started in a second. I just wanted to give it a minute because like I said, I did tell everybody at the end of my live a couple hours ago that before I went live again, I would warn everybody, and I really did feel bad about that, but I just couldn't because I had set up 2 different cameras, which I thought was really cool. But and again, I don't know if I'll ever get this to work again. Okay, so I'm gonna run over. Let's see. I'm gonna go over to the other camera, to the other thing, and try to stay in the lines. Now, one of the problems here, guys, is that when do I go live typically? I always go live if there's a Supreme Court case. But it's a little hard to tell other times because I'm often writing. I have a lot of work to do. Hold on a sec. How am I gonna do? Well, let's see. Yeah, all right, well, whatever. Okay. And there we are. Hi. Okay, so we're going to get started on Buckley v. Valeo. It's also going to be a little bit hard for me to see. I am able to look. I have a screen that I've kind of moved over here so that I can, look over and see it, but it's really small. This was the first time I've ever done this, so I wasn't totally prepared for how it was going to look. And when I moved it over onto that smaller screen, the typing got really small, so it's hard to read. And if I get too stuck in looking at the typing, this will take us 3 days, so we can't do that. So I do apologize. I'll be kind of bouncing back and forth a little bit. Hey, Betharoni! But I do want to put up here so that you guys know what case we're looking at, because I'm sure people will keep asking, and so I'd like to just say that this is Buckley v. Valeo. Tell you what, how about I put it over here so it's... Okay, So this is about one of the key things here is, and this, by the way, confused the heck out of me because I kept reading, they had multiple paragraphs where they would sort of say the same thing and end up with a different conclusion. And I kept reading this paragraph. I'm like, how are you saying something different in paragraph 1 and paragraph 2? Because it looks like the exact same words. How are you coming to a different conclusion? And the thing was, they were talking about contributions and expenditures. And this apparently is one of the kind of big things that came out of this case, is that the court decided to separate, well, make a big deal anyway, out of the separation of contributions versus expenditures. And I kept reading those two words as sort of the same thing, because I was my eyes were glazing over and they're big words. But they are different things, and the court's going to go into why. But let's start out here with the actual rule that they're talking about and what's so important here. This is a spending limit. This is a limit on how much money you're allowed to spend. And individual political contributions are limited to $1,000 for a single candidate. Okay, so every person is allowed to contribute $1,000 to a candidate. And then there's an annual maximum too. Expenditures by a person or a group relative to a candidate is also limited to $1,000. Okay? Contribution limited to $1,000. Expenditure related to a candidate limited to $1,000. And I was really having trouble. I just kept reading this and reading this and reading this and not realizing they were dividing the two. Let me see here. This case is the reason you can buy U.S. elections. It very much is. But it could get way worse tomorrow. We'll find out. And then what else does it do here? Contributions and expenditures must be reported. This also created a system for public funding so that you have the option, if you want, to have your campaign funded through a government funding program. But nobody ever chooses that because it means you're not allowed to take donations. And it's less money. And then this also set up the FEC to oversee all of this, the Federal Election Commission. By the way, this case was brought by James Buckley, who was the brother of William F. Buckley. If anybody knows William F. Buckley, William F. Buckley is an interesting character. He was a very famous Massachusetts conservative, which seems like a bit of a contradiction in terms, but it was a different time. Okay. So let's see here. The First Amendment protections. So one of the kind of key things here is that the First Amendment really is rooted in the idea of protecting the free flow of ideas more in politics than anywhere else. The theory was that in England, and particularly England, a couple of hundred years before, let's say like 1400, something like that, before anybody could vote, it really didn't matter if peasants knew what was going on because they weren't voting. So them kind of understanding what was really going on in the government was sort of irrelevant, right? There was no justification for making sure that they had a free access to information and that they really knew what Parliament was up to and what the king was up to. There's like a theoretical reason for it, like you may want them to know what's going on, but as far as making sure that the government operates properly, there's no justification for it. Contrary to that, in America, because our people in general, I don't want to say this, but our peasants, everybody, makes the decisions about the government, we need to know what's going on. We have to be able to choose these people with as much information as possible. So making sure that that information flows as freely as possible is crucial to our government actually operating properly. Now, is any of this without problem? I mean, obviously there's all kinds of, but wait a minute, hold on. Obviously. But, take a step back and, from 1,000 feet up, let's just accept that for the moment. But the idea is that in American democracy, we have free speech because, the justification for it is rooted in the need of everybody to know what's going on because the government can't function without that. And that is different from other governments. That's different from a lot of other governments, especially back at this time, where the regular people didn't need to know what was going on. We may feel that they should have known what's going on. They may have wanted to know what's going on. But for the government to function, they didn't need to know what's going on. And that is a difference. So, because of that, the idea of restriction of free speech starts in politics. The idea of protecting free speech starts in politics. It begins in politics. It begins in making sure that political ideas, political discussion, and political grandstanding is not repressed, because people who are running for office are supposed to be able to get their message out, and are supposed to be able to talk and speak freely. And so some of the things that get talked about here are, for example, the idea that an incumbent, somebody who's already elected, has a little bit more power to speak because people are already listening to them. Somebody who's running against an incumbent going to have a little bit of a tougher time getting their message out there, and so that might be a concern, and it is sort of discussed a couple of times. But we are always very concerned and very, very hesitant to allow any law that infringes in the political sphere on the right to free speech, because that's where the right to free speech is rooted in America. And America, in theory, can't operate without it. And I'm just occasionally checking over to make sure that I'm not missing anything. Okay. Oh, wait, one thing, sorry. Hold on. Okay. So let's see here. So the other thing that's important is, they quote New York Times v. Sullivan, which is a case that I talked about in when we were talking about the Donald Trump lawsuit against, who was he suing? It wasn't the New York Times, I don't think, but he was suing somebody, one of the newspapers. And the idea was, is he a private citizen? Is he able to sue a newspaper for not making sure that what they said about him was true? And the root, there's this case called New York Times v. Sullivan, which they cite, which says that when you are running for office, a newspaper has a little bit more flexibility to print things about you, and a little bit less liability for saying something that doesn't end up being true, because we want to maximize their ability to get information out there and not have them worry about spreading it as much. So they cite New York Times v. Sullivan. Debate on public issues should be uninhibited, robust, and wide open. The ability of the citizenry to make informed choices among candidates for office is essential. Okay, that's concept one. Concept two is about political association, because this is going to come down to political parties a great deal. And part of the First Amendment is also the freedom to associate with whomever you want. You're allowed to come together in groups with anybody you want. And there's a tendency to cite this case. I find that this case tends to get cited when, I don't know how else to say it. It's almost cited in, I don't want to say ironically, but it seems to get cited more often by conservative justices, but which is NAACP v. Alabama, the right of the members of the NAACP to associate. But the idea is that as members of a party, you have a pretty strong right to associate together. So that's also a really important thing. Okay. We have a question here about whether whether spending money is conduct or direct speech. And, of course, the two sides disagree. Appellees say that it's conduct. Its effect on speech is incidental. You're just passing money over. It just happens to involve speech. And the appellants, the party, says that the contributions themselves basically are speech. They're a form of speech. So we look at a case called O'Brien. O'Brien was a draft card burning case. And I don't love this, and I had some trouble getting my head around this, but the idea was that Mr. O'Brien burned his draft card. And the Supreme Court, what's the word here? They allowed his conviction to stand. They allowed him to remain convicted for burning his draft card, even though he said, and they agreed, that burning his draft card was a symbolic speech thing. He was speaking, and he was criticizing the war, because the law that made burning draft cards illegal was not about suppressing speech. It was about this whole other thing that was about, keeping track of people and doing this other stuff and da-da-da-da. It wasn't about what he was talking about. That part was fine. His speech was fine. He's allowed to protest the war all he wants. But this other thing that he did, destroying this piece of property that we needed, that was not fine. I don't know how they drew that line. They say the non-speech element, the part of it that wasn't speech, was incidental. The speaking part was just kind of, it sort of accidentally happened while he was destroying the piece of property. And I don't know how I feel about that, but that was also 1968, so things have probably evolved a bit. But it's still how we're rooted here. They also say, though, that right after going through that, we also say that it doesn't apply because the expenditure of money just doesn't, it's not the same as destroying a draft card. Some forms of communication made possible by giving and spending money involve speech alone. Some involve conduct primarily, and some involve a combination of the two. In other words, it's just not clear, which I don't think the other one was clear either, but they're like, it's too intertwined, we can't do that. But essentially, the existence of money didn't automatically introduce non-speech elements when it came to donations. Okay. So let's see here. I think I can skip over. Oh, somebody asked me earlier today about time, place, and manner. They do say here that the Act's contribution and expenditure limits can be sustained. Let's see here. Oh, they cannot be sustained by reference to time, place, and manner decisions. The critical difference between those cases is this Act's limitations impose direct quantity restrictions on political communications in addition to reasonable time, place, and manner restrictions otherwise imposed. Again, I feel like they drew a real thin line there that I don't love, but there's going to be a lot of those here. So the overall picture we're still getting to. A lot of this I'm just kind of making sure we're getting to. Okay, so here is where we get to our big slice. A restriction on money reduces the quantity of expression. It restricts the number of issues discussed, the depth of exploration, and the size of audience reached. So they're saying that when you cut down the money that goes into a campaign, you cut down on what they're allowed to talk about, how much they're allowed to delve into a particular issue, and cut down on the number of issues they're allowed to talk about, as well as how many people they're allowed to talk about. So you do change how they express themselves. So they say the expenditure limits. And here's where we get into the difference between expenditures and contributions. And this is going to be basically the crux of this case. So if you're lost up until now, don't worry about it, because here's where we're getting to the meat. Expenditures. Expenditures mean a limitation on how much money I, Brian, as a regular Joe on the street, who wants to spend my own money to go support a candidate. Hold on. You know who I'm reaching for, right? Oh, you're not going to squeak for me? All right, well, candidate Ducky. I want to go support candidate Ducky. I'm going to spend some of my own money and buy an ad supporting candidate Ducky. And that is an expenditure. That is me spending my own money to go make a commercial and pay for it myself about something I feel strongly about. I have not talked to candidate Ducky. We've had no communication at all. That is an expenditure, and that is different from me giving candidate Ducky my money for candidate Ducky to use to speak for him or herself. I'm not sure. So that is the difference between an expenditure, me spending my own money, and a contribution, me giving my money to Ducky to spend for Ducky's self. Okay? Expenditure versus contribution. And because restricting money reduces the quantity of expression, the number of issues you can talk about, all of that stuff, a law is not allowed to tell me, Brian, that I can't spend my own money to talk about whatever the heck I want. No law can tell me that I am not allowed to expend my own money. And that is what this case says. Expenditure limits are essentially going to be unconstitutional, and we'll get to more of it in a second. Contribution limits, on the other hand, are a different thing. Contribution limits that say I'm handing money over are going to be different. That is where I give my money to somebody else. I'm going to give my money to Ducky for Ducky to spend. Okay? That's going to be a different thing because it's just different, and we're going to get to why in a minute. And let me see whether we're going to get to it here or in a minute, because okay. But, okay, expenditures. Let's see here. Expenditures. I spend my money to say what I want. Contribution, I give my money to a candidate. Okay? For them to speak. All right, let's see where we are here. So, a limitation on the amount that one person can contribute is only a marginal restriction on their ability to engage in free communication. A contribution is a general expression of support. It means, I like you, Ducky. I'm a fan of yours. But it does not communicate the underlying basis for support. It's not telling them why I like them. It's not saying I really like your position on duck support. I don't know. It just says, here's money. The quantity of communication by the country, so the amount of money that I give them tells them how much I like them, but it's all kind of a symbolic act. It's just sort of changing the intensity of how much I support them. Until a different person, Ducky, takes those contributions and turns them into squeaks, turns them into speech. Okay? So, this is the rule. This is what we're saying here. Okay. The overall effect of the contribution ceilings, the maximum amount of contribution is only to require candidates to raise funds from a greater number of persons. Now, what I didn't say is that expenditure and contribution limits also applied to PACs. Oh, somebody just got me. Somebody just hit my live, and you guys got to see Obi. They also apply to PACs and to what do you call it? Committees, to campaign committees, to the DNC, to the RNC, to all of them. They are also limited in how much they're allowed to give. And so directly to candidates. Let me see here. So compel people who would otherwise... Oh, and so basically what they're saying is all this makes these organizations and these campaigns do is find more people to contribute to get the same amount of money. So that's not necessarily a bad thing. The other question is about associational freedoms. Are people allowed to come together? Making a contribution serves to affiliate people with a candidate, brings them together. They pool their resources to share a single message. But leave the Act's contribution ceilings limit one important means of associating with a candidate or committee, but leave the contributor free to become a member of any political association. So, yeah, you're only allowed to give so much, but you can join anything you want. So they're saying this does not infringe on your ability to join in any way. This doesn't cut down on your associational freedom. By contrast, the Act's $1,000 limitation on independent expenditures, okay, so IEs, independent expenditures. Once again, we're talking about me spending my own money, and let's pretend, well, okay, here we go. So, Ducky here is running a campaign and has the Ducky for President campaign going. I am going to make an ad for Ducky for President. It is paid for by Brino. It has nothing to do with Ducky for President. Ducky for President is not contacted. It might not even be helpful because we haven't coordinated in any way, and I might be using a message that Ducky for President does not really like. But I'm going out and making an independent expenditure that is a Ducky for President ad. Independent expenditures are a very common thing that the DNC and RNC and those organizations will do to support a candidate without directly giving money to the candidate. That's an independent expenditure, because even though I'm using me as an example, these also apply to organizations, to groups. So, oh, sorry, let's see here. So I will get to quid pro quos in a minute. Quid pro quos are something we're going to talk about. This is going to be really important. Quid pro quos are going to be very, very important. But give me a second. So, by contrast, the $1,000 limit on independent expenditures relative to a clearly identified candidate precludes most associations from effectively amplifying the voice of their adherents. So, if my group, the We Love Ducky Association, decides that we collectively each want to put money in and buy that advertisement to support Ducky, that precludes our association from effectively amplifying the voice of our group and the original basis for the recognition of the First Amendment protection of freedom of association. So, once again, expenditures, direct expenditures, cannot be restricted. Who is they? This is a Supreme Court case. This is Buckley v. Valeo from the Supreme Court in 1976. This is my Law of Democracy case book. It's just a bunch of democracy-related legal cases that have been very heavily underlined and annotated by me. So the Act's restriction on First Amendment through expenditure restrictions far outweigh the contribution restrictions. So its expenditure ceilings impose significantly more severe restrictions on protected freedoms than the limitations on financial contribution. So once again, they're just saying expenditures, huge, huge, huge drain on your First Amendment rights. Contributions, not so much. We don't mind. We don't think that's as big of a deal. So we're going to go ahead and allow contribution limits to continue. Expenditure limits, we can't allow that. Okay, and now they're going to delve into more detail here. Let's see here. We're going to talk about why. Oh, okay, so real fast, for those of you who have never seen this, there is a chart of how the Supreme Court generally decides whether or not something is constitutional. If a law is written, and the Constitution is implicated in some way, the Supreme Court needs to decide whether or not the government really, really needs this law for some reason. They are willing to allow some constitutional guarantees to be abridged if it's something really, really important. That's basically how these decisions are made, okay? So as a general rule, if the law is we'll get here in a second, to a government purpose, goal. If the law is to a government goal, then they will allow the law to stand. And usually those break down into 3 categories. Hold on, I have an example in here somewhere. I know I wrote it in here yesterday or 2 days ago. Where did I put it? Give me one sec, guys. It was later than I thought it was. Oh. Oh, come on. I'll be real mad if I can't find it. Because I can't think of an example off the top of my head. Here we go. Okay. So, as a general rule, the kind of more important the the constitutional right is, the tougher the test is going to be, okay? So up at the top, we usually have like kind of a weak test that's pretty easy to pass. Down at the bottom, we have something called strict scrutiny, which is really hard to pass. It's like the law is like absolutely necessary for the government goal to be achieved, okay? But this is generally, we're ending up somewhere in something called intermediate land, which is somewhere in the middle here. And the law that I think they've come up with here, and I'll see if we come back to it, the law is close, but so anyway, at least this is an example for you. The law, oh, here, I'll do it in another color so it's easy to see. The law is closely drawn to match a sufficiently important government goal, okay? This is just one example of kind of an intermediate level of scrutiny. And what the Supreme Court will say is if we're not dealing with a super, super crazy constitutional violation, they will allow a law to stand if the law is closely drawn. It's written pretty narrowly, but not super narrowly, but narrowly enough to match a sufficiently important, something that's pretty important, doesn't have to be the most important thing in the world, but pretty important government goal, okay? And this is, it's a standard of review. It's one of the standards of review, and there's usually kind of three of these. It's strict scrutiny, intermediate scrutiny, and rational basis scrutiny. And I'm sorry to sort of jump around here, but I wanted to make sure I'd at least run through that. Do IEs ever get investigated? Yes. Yes, they do. Okay. So anyway, I at least want to give you an example of how a standard of review works because they're kind of developing a new one here, and they have a tendency to do that from time to time. So I at least wanted to make sure we knew what a standard of review was in general. I have a really nice chart where I lay out three of these, and it sort of looks like this, but I didn't want to go into the whole thing right now. So the appellees argue that the Act's restrictions are justified by three governmental interests. These are the interests that they are trying to get to, okay? Prevention of corruption, muting affluent voices, and slowing down the skyrocketing costs of campaigning to open up the system to more people. Okay? So these are the three government goals that they say this law is trying to reach. Okay? And so the question is eventually going to be, depending on which standard of review they choose, this is the one they end up choosing, but let's pretend, whether the law is closely drawn to match those goals, or at least one of those goals. So their goal, again, is prevention of corruption, muting the voices of affluent people. And they don't say not stopping their voices, but muting them, slowing them down so that not only affluent people are allowed in the political sphere. And then putting a brake on the skyrocketing cost of political campaigns to serve to open the political system more widely to candidates without access to sources of large amounts of money. Which is kind of the same as the second one, but a little bit more broadly, just to kind of slow. Remember how look at how expensive political campaigns have gotten. So they're saying to kind of slow that down. It is unnecessary to look beyond the Act's primary purpose to limit this whole thing. Under a system of private financing of elections, which is what we have, this system did set up a public finance option, but nobody ever uses it. A candidate lacking immense personal or family wealth must depend on financial contributions from others. The integrity of our system of representation or of representative democracy is therefore undermined to the extent that large contributions are given to secure, what is it? Who just said it? a political quid pro quo. So there, whoever just said that, there we go. So in order for a normal person, any normal person, to get elected, they're going to have to get a bunch of money. And in order to get a bunch of money, you're going to have to agree to this for that, quid pro quo. And that undermines the integrity of our system. So that is just government goal number 1, okay? Prevention of corruption. Of almost equal, although the scope of those practices can never be reliably ascertained, there were a number of deeply disturbing examples that surfaced in 1972, which I don't know what that is off the top of my head. Of almost equal concern as the danger of actual quid pro quo is the possibility of the appearance of quid pro quo, because just the idea, just people thinking that quid pro quo is going on, can hurt things. Let's see here. Public awareness of the opportunities for abuse is enough for Congress to legitimately conclude that the avoidance of appearance of improper influence is critical. And this would be enough, they say, for Congress to have written this law. It doesn't have to be actual quid pro quo, like that's not happening, but even people kind of stepping out of and not participating in the political system because they're like, everything's already screwed anyway, what's the point? They're like, that's enough for Congress to have made this decision. Okay. Every time something moves over there, I want to make sure it's not. So the other side says that there are less restrictive means that exist, and this is our closely drawn side. So sure, the government goal may be sufficiently important, but there are less restrictive means of doing this. There are better ways to do it, and this is going to be super important because this is probably what's going to get us tomorrow. There are less restrictive means that exist. Bribery laws and disclosure requirements, because those exist. There are criminal bribery laws out there that you can go to jail for accepting a bribe. And that, the other side of this case says, should be enough. We don't need restrictions on expenditures because we have bribery laws in place and disclosure requirements in place. Everybody has to say how much money they gave and where it came from and all that stuff. And that should be enough. And I'll tell you why this is so important. I'm just going to skip to this, guys, because in Colorado 2, I think, which is the one they're talking about overturning tomorrow, Justice Thomas's dissent in Colorado 2 says exactly that. It says, we don't need any of this. We have anti-bribery laws and disclosure requirements, and that's all we need. So that is what we're going to be up against tomorrow. That is exactly what's going to come up, that we don't need to cut down the amount of money people put in because we have other laws in place that stop illegal quid pro quos from happening. And yeah, it's nearly impossible to prove. I have to go to bed soon and miss the first part. Do I have a YouTube channel? I do, and this is actually going on that as well, so you can watch this there. I will also be doing I'm going to have to come up with a 10-minute version of this or less to come out tomorrow morning before we go live at 10 a.m. With the oral arguments on this, on the case that's following this up. So, I will hopefully have that recorded and released in the morning. Same thing at Brino DC. And isn't there a doctrine about one individual must have the same voice as the other? Wes, oh yeah. Wes, first of all, I'm Greek, so I can't, my hands just, I'm Greek and I learned sign language when I was younger, and I think it makes my hands move even more. The defendant here in this case was, it was Valeo, and I looked it up yesterday who that was, and now I can't remember. Tomorrow it will be the state of Colorado. No, it won't, will it? No, it'll be the FEC, the Federal Election Commission. But the FEC is not defending the case because the FEC is actually appearing along with the NRSC tomorrow. So the Supreme Court had to appoint an amicus to defend the case tomorrow, and that person's not even defending the case. So the DNC had to bring in another person to actually defend the case. So, yeah. So I have to get up at 5 a.m. Shelly, what time zone are you in? So it's going to be 10 a.m. Eastern time will be when we go live. That's what time the Supreme Court starts. I mean, you know, it'll all be streamed, so you can watch it anytime. Alaska. Shouldn't that be, isn't that later? Oh, it is earlier. Yeah. Or you can watch, I mean, it'll all be streamed and you can watch it later. Sorry. Yeah, I know that stinks. Okay. So let's see if what else we got in under this. Okay. Apart from the First Amendment concerns, the appellants argue that contribution limitations. The last thing is whether they make it more difficult for incumbents to challenge position. They said there's no evidence to support that, so they didn't take that up. But okay, now we look at expenditure limitations. So if anybody's coming in new, this is kind of the big thing here. It will be on the YT once. It takes a little while to process, but it will be. So one more time, expenditures mean that me personally, or my group of people are directly going to spend our money to make a statement, put out an ad, something like that, versus a contribution, which is where we give our money to a candidate. This case, Buckley, says that limits on expenditures are First Amendment violations, but limits on contributions are not. And the reason is overwhelmingly that it's less of a giving money to a person shows your support, but giving $5, $10, $20, $50 just shows how much you support them. It doesn't actually act as speech at that point. How much you give them is not speech. Okay, so now we're going to go into and then the other thing was, of course, the back and forth. Did they decide here? Sure they did. So they said, you know, in deciding whether or not bribery laws were enough, laws making criminal the giving and taking of bribes deal only with the most blatant and specific attempts. So like you said, that's almost impossible to prove. And Congress was surely entitled to conclude that disclosures were only a partial measure and just weren't enough. So they said this is fine. This law is closely drawn to match a sufficiently important government goal of preventing corruption. Okay, now let's look at expenditures. So, expenditures, we say everybody who is not a candidate or an institution or a member of the press does not have the same voice relative to a clearly identified candidate. So the government's interest in preventing corruption is inadequate. The law is not enough. The goal is not enough to justify stopping their voice completely. Sorry, I'm skipping a little bit here. On an expenditure. We're moving over to an expenditure here. This is not a contribution. Contributions are fine. The independent expenditure ceiling fails to serve a substantial government interest in stemming corruption. Independent expenditures pose less of a direct corruption threat. And I find this an interesting argument. They're saying that my organization or me personally making an ad for Ducky here is less of a direct corruption threat, partially because of what I explained a minute ago, which is that, if I don't actually talk to Ducky's campaign, then the ad I make might actually hurt them. We don't know. It might have virtually the same value to the candidate, but it might not. May well provide little assistance to the candidate's campaign and indeed may be counterproductive. But it's certainly, if I don't have a chance to talk to Ducky and say, hey, I am going to spend money on your campaign, then it alleviates the danger that expenditures will be given as a quid pro quo, which does not feel correct. But I definitely have not spoken to Ducky and said, I will do this in exchange for, so technically they are sort of correct. Yes, Snyder. And let's see here. Thank you, Froggy. Okay. Okay. Oh, wait, so I wrote most important quote here, so this is let's see here. Not this yet. See if I can read my own handwriting. I have terrible. Independent expenditure ceiling fails to serve a substantial government interest. Because they're saying it doesn't stop quid pro quos. It heavily burdens First Amendment expression, and advocacy gets as much of the election or defeat of candidates. Advocacy of the election or defeat of candidates for federal office is no less entitled to protection than the discussion of political policy. So they're saying me advocating for Ducky to get hired is the same as me advocating for freedom of speech in general or other political ideas. And our government, again, considers this idea of free political speech is core to the operation of our government. It has to be at the center of our government. It is argued, however, that the ancillary government interest in equalizing relative ability of individuals to influence... So there's this other discussion about evening out the ability of people to influence the outcome of elections, okay? I'm poor. I only have $10. My friend over there has plenty of money. Shouldn't we both be able to get our ideas out there in the same way? We may both have good ideas. And the government interest, it says that there is a government interest in equalizing the relative ability, our relative ability to influence the outcome of elections. Okay? And so this is the question now. Should we be evened out somehow? And this is like the most important quote from this case. The concept that government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment, which was designed to secure the widest possible dissemination of information from diverse and antagonistic sources and to assure unfettered interchange of ideas for the bringing about of political and social changes desired by the people. Okay. This is our quote. It's fun. I underlined it and I made all kinds of things, and then as I was reading later, somebody was like, that's the quote from the thing. And I was like, oh, good, I already noted it. So they're saying that the idea of evening out people so that we can all get a chance to speak is not part of free speech. That is contrary to the First Amendment. We want the widest possible dissemination of information from diverse and antagonistic sources, assure unfettered interchange of ideas, and the idea of holding one person back to let everybody get a chance is fettering, for lack of a better word. So I don't know whether that's correct or not, but that is the idea. What level of coordination does it count as quid pro quo? There is an answer to that question, and it's not here yet, but we are going to get there, because it turns out that they have a very limited definition of quid pro quo that is disappointingly limited. But I can't remember. I'm not going to be able to find it until we get to it. The interest in equalizing financial resources of candidates is no more convincing, and they're basically just going to repeat themselves. There is nothing invidious, improper, or unhealthy in permitting such funds to be spent to carry the candidate's message to the electorate. First Amendment denies government the power to determine spending to promote one's political views. It's wasteful, excessive, or unwise. In a free society ordained by our Constitution, it is not the government, but the people individually, as citizens, and candidates collectively, as associations and political committees, who must retain control over the quantity and range of debate. Interesting, because I am a little bit torn, because I get the theory that they're going for, and yet I feel like they are stepping on their own theories sometimes. So I don't know. I don't know how I feel about this anyway, but the end result is, so we've gotten to the end of the main case here, the main opinion here. There's a couple of concurrences. Justice White, who will be banging this drum for another 20 years or another 10 years, says money is not speech. It defrays the cost of speech. That's what it does. So that's going to be Justice White's thing forever. Justice Berger says Congress intended to regulate all aspects of federal campaign finances, and we may have just screwed up this law by cutting off half of it. So he's like, I'm not sure that this law exists anymore now with what we've done. But the big thing out of this case is the difference between expenditures and contributions, and restricting expenditures is no longer allowed. Restricting contributions is. And this is the beginning of what's called the independent expenditure. It becomes a very big thing from this point on. And so parties will start they will basically send a whole separate campaign to an area that is a completely funded campaign. It's like, it looks like the same as any other campaign, but it is an independent expenditure. They don't talk to each other at all, and it's called an IE. IE. I have worked for an IE. I didn't even know it, actually, at the time. I mean, I sort of did, but I didn't understand what it meant. So yeah. The one other thing here that I want to point out is that Buckley works on these 4 major questions. That's sort of what it's known for. Let me see if I can figure out what they are. So it's called the Buckley framework. The argument that restrictions could be justified on fairness grounds is per se unconstitutional. So fairness is not allowed to be part of the discussion. That's number 1. Money as speech is kind of a question. Justice White says no. Justice Stevens says money is property, not speech. So it's kind of a discussion about whether money is speech or not. That's kind of the second thing that comes out of it. Number 3, corruption is the only justification for limiting spending. Here we go. Okay, so corruption becomes, that's the only thing they discuss. The other ones, they're like, yeah, we don't need to talk about those, but that also means they kind of blew them off. Corruption and the appearance of corruption, which basically a lot of stuff is going to hang on the appearance of corruption from now on, because it gives us kind of a back door. But corruption is going to become the only justification for limiting spending from this point on. And I know it's in here somewhere. Well, and then number 4, the difference, and then the difference between contributions and expenditures is obviously the big one that comes out of this. Thank you very much, Brandon. Could the government elevate other voices on part? Well, that's the idea, is that no, they can't, according to this. Okay, so I'm going to skip forward a bit because now the next like 5 cases are all just breakdowns of Buckley. And they just keep talking about Buckley for years. By the way, Buckley is not fully challenged until 2006, I don't think. So it's, I mean, Buckley just basically stands in that position until 2006, from 1976. So the next big thing we're going to hit, though, is, well, I'm sorry, that is not exactly correct. Buckley is challenged. It's just contribution limits aren't really challenged until, nobody's contribution limits are challenged until 2006, when Vermont writes contribution limits that are really, really low, and they get challenged in 2006 in Randall v. Sorrell. But anyway, all right, so now we got Colorado 1 and Colorado 2. I'm going to try to bring this home because this is really what we're talking about tomorrow, is Colorado 1 and Colorado 2, okay? So let's see here. Colorado v. Oh, I see. Never mind. I'm sorry. It's Colorado Republican Hold on. Colorado Republican Federal Campaign Committee 1 and 2. One is in 1996. One is in 2001. And so the deal with Colorado 1 is that the Colorado Campaign Committee bought an ad. They bought an ad attacking the Democratic candidate, a guy named Tim Wirth. And they had not picked a candidate yet. So it was definitely not in coordination with anybody. What was the deal here? There's a more of a story here. Oh, right. Okay. So there were special rules for the parties, because whereas the rest of us all have kind of, relatively low limits, party limits allowed them to spend up to $103,000 in expenditures, as long as they were totally independent. But the question was this completely independent? Because it's kind of hard for a party to be independent of their candidates, right? So the First Amendment here prohibits expenditures by a party with no coordination with a campaign. That is sort of what we're headed for here, is that in this case, because they bought this campaign ad, because they made an expenditure as a party before this guy was even picked, it was definitely independent. There was no way that this was, and I apologize, I said the independent expenditures really got big after Buckley. They did not get big until this one, 1996. Yeah. Okay, I may have screwed something up there. Okay, hold on. Coordinated expenditures versus independent expenditures. Sorry, guys. This is why we're here. This is why we're here. Because I am still making sure that I've got this right. So here, the court considered the constitutionality of limits on party coordinated expenditures. Whether limits could constitutionally apply to party spending that attacked Democratic Party's incumbent before the Republican nominee had been chosen. Court ruled that they could not. When the case came up the second time, the Republican Party challenged the limits on their face, and the court upheld the limits, reaffirming the basic Buckley framework, distinguishing independent expenditures from coordinated expenditures, which were basically contributions. Okay, so here's what we're doing here. And I may need to do another read through on this, and this is why I was doing this with you guys, by the way, is that I'd read all of this stuff. You know, this is probably 100 and some pages over the course of 2 days, and it was all kind of banging off of each other and was confusing me. So I needed to go through and explain it to somebody so that I could kind of pull it all out before, because tomorrow morning I have to explain this again. All right, I think I got this right now. So the RNC, the Republican committee in Colorado released an ad attacking the Democratic candidate, but they had not chosen a candidate themselves yet, so it could not be a coordinated ad. They couldn't have coordinated with a political committee or a political campaign that didn't exist yet, right? And so this was an independent expenditure, and this was allowed. Later, they wanted to do a coordinated ad, which is one where I, as a party, agree. I go in with my friend Ducky here, and I'm like, I'm going to make an ad, I'm going to pay for it, but we're going to talk to them and see what they want the ad to be about and all that kind of stuff and make sure it's coordinated, make sure they like it. Oh, weird. Hold on. All right, I don't know what happened, but for some reason it knocked me off of... I gotta figure out what the heck is going on with Facebook, or with TikTok. They keep knocking me out. They don't seem to see me as doing anything. All right, so that's the deal. They got there's a question as to whether that was an expenditure or a contribution. And they said that if the party is acting in concert with the campaign, then that's more like a contribution. They're essentially contributing the money to the campaign at that point. It's basically a contribution. That is allowed to be withheld. That's Colorado 2. Colorado 1 was about essentially an independent expenditure, and that was not allowed to be restricted. The party was allowed to put out an ad that went against Ducky's opponent because Ducky wasn't running yet. It was clearly not in cooperation with Ducky. And so that's the difference between Colorado 1 and Colorado 2. Tomorrow, we will be challenging Colorado 2. The court a lot of people on the court want to overturn Colorado 2 and say that both of these restrictions are now unconstitutional. And none of them are closely drawn to match a sufficiently important government goal. And that's what Justice Thomas says in his dissent for Colorado 2. I think it's Colorado 2, right? Is that Thomas? Yeah. I still would strike down the party expenditure provision. In addition to bribery laws and disclosure laws, the government has other options that would not entail restriction of political parties' First Amendment rights. Earmarking stuff. Anyway, so he thinks there's plenty of stuff in place to stop this sort of corruption, and we don't need to restrict people's spending. So that is essentially what we're going to be talking about tomorrow morning. Okay, I'm kind of exhausted at this point, so I am going to come back over here for a minute and hold on. Let's try. Okay. So I don't know what happened. For those of you who are on TikTok, I do apologize that I don't. For some reason, it said that it had it kicked me off because I was for lack of activity. So I'm not sure what that's about, but I'll figure that out somehow. That might be why they keep. I don't know. All right. Well, so I'm like I said, I'm getting a little tongue-tied because now this is now. How long have I been going? This is my second live of the day. My first one was 3 hours long, so I'm like blah, 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 blah. And now I have to get this ready for tomorrow morning. So here's what we're going to do. Tomorrow morning, we're going to go live again at 10 a.m. Before that, I should have a morning report recorded that will kind of run through what we just did, but in just a couple of minutes, hopefully, if I can get it out. And also another story that I have today, kind of interesting, about if any of you have ever seen the old executive office building. It's I think a very beautiful building in Washington, D.C. that looks like a giant wedding cake. And just like the East Wing, Donald Trump would like to, this time he doesn't want to knock it down, he wants to repaint it. It is a gray granite building. It's beautiful, and he wants to paint it white because he says gray is for funerals. So there was a hearing this morning about it, and I've got some special information from that, so I'm going to talk about that in the morning as well. And yeah, I'll have all that early tomorrow morning, hopefully, and then followed by another 3 hours of live where we will hear 2 hours, something like that, where we will hear them talk about Colorado 2 and all of this stuff that we've talked about today, and argue about a lot of what you're going to hear is expenditures and contributions and kind of the differences and whether or not contributions can still be reduced and held down in order to match a sufficiently important government goal of preventing corruption, which would be quid pro quo. So keep your eye out for all of that, your ear out for all of that. And I am going to go probably take another short nap before I go and write this script because my voice is starting to go. But I will see you all tomorrow morning bright and early. And thank you all for sitting and listening and helping me get through this because it's a lot of information. All right. Thanks a lot, everybody. And I will see you tomorrow.